Good afternoon and welcome to today's presentation, The Internet of Evidence, Little Brother is Watching You and He's Taking Notes. Before we begin our presentation today, I would like to take a few moments to go over some housekeeping items. We will be recording today's webinar, and this presentation is CLE approved, and we will be asking you to enter a passcode for CLE credit a few times throughout the presentation. In today's webinar, Mr. Norris will discuss how sensor data and its connectivity, what he has come to call the Internet of Evidence, can support determination of timelines, identities of actors and alibis, intentions of actors, external and environmental conditions, as well as who knew what and when they knew it. To give you a little background about our presenter, Wayne Norris, he is a corporate and technical management consultant, software engineer, sales and marketing executive, financial analyst, business plan author, and physicist. He has 45 years of professional experience and 55 years of experience writing computer software, beginning in 1959 at the age of 12. He is a former chief scientist in the counterterrorism community and also in the environmental oil spill community, holds 5 patents in nuclear sensing technology, and acts as a patent advisor. Mr. Norris has been an expert witness for issues in software technology, intellectual property, technology industry compensation, and conduct of corporate officers in federal and state courts. For those of our attendees who require a code word for tracking purposes, the code word for today is evidence. During the presentation, we will take short breaks, and during that time, we will ask that you enter this code into the chat feature for CLE reporting purposes. The chat feature is located to the right of your screen. Please remember that if you are applying for CLE credit, you must log onto the computer as yourself. If you have attempted to log on and received an error, or if you are listening via telephone, please email the passcode both times that is requested, and please state the time that you have entered your code in your email. Also, please remember to complete the survey that will appear on your screen at the end of the presentation. As a provider of CLE credits, we are required to have supportive information that you have attended, and in many states the survey is required. Mr. Norris welcomes your questions. Please use the chat feature to submit your questions throughout the presentation. We will take intermittent breaks so that Mr. Norris can respond. Thank you all again for attending today, and Wayne, the presentation is now turned over to you.
Thank you very much. And just actually to be sure, I use the arrows at the top to the next page. Okay. Thank you everyone for attending. I'm actually very excited about this whole topic. It's very easy to read about the wonders of the Internet. It's pretty hard actually not to if you are on the Internet, because self-congratulatory articles are coming down every day. But for those of you who are out in the trenches working every day as attorneys, advancing the cause of rule of law in the world's leading democracy, it's a trench warfare battle every day. And what I want to try to focus on is the things that are actually useful in what people do as real attorneys on an everyday basis. But I decided that I would use the common terminology because I think it's actually very demonstrative. Little brother is watching you, and he's taking notes. The idea for this came to me from 2 cases that I did in which what I could only later call the Internet of Evidence were major factors. And although they were multi-week, they both actually intersected in a single week, and it was impossible to ignore. Specifically, there is a vast and really ever-increasing array of sensors and data recorders that are out there in the environment. And they have the opportunity to assist in establishing, and I was trying to be kind of cute here, truth, justice, in the American way. Apologies to Superman. Those of us of a certain age used to run home from school to watch it every day when it was on. But it really does contain the ability to materially alter the way jurisprudence is viewed and practiced. Some of you may hold advanced degrees, some of you may not have engineering backgrounds, so just for review so that we're all on the same page, sensors are devices that detect data. Sometimes they record them. More often than not these days they are. An example of a sensor that doesn't record data is the thermometer that we've all used to take our temperature. But if you remember the glass thermometer days, you read it, and you shook it down, and then you put it away. Today, it might record. I have a blood pressure meter that I use at my home, and it records for 30 separate samples. And more sensors are becoming like that. This is just a review of them. And because you're all clever folks, you're all attorneys, you may have some lights going off right now. Modern digital cameras are an example. They actually record time, date, and even often GPS coordinates inside the picture files. The picture files, depending upon the camera, are either a RAW or a JPEG or some other type of format. But they have headers that are known as EXIF headers. There's a reference that you could look it up. And in many cases, they actually have all this data right inside the picture, so that if you copy it, it's still there. But in addition, each one of those little cards inside the camera has a file system, usually written by Microsoft, usually called FAT32. That time data information is also written to the file system of the camera, so that they're there to compare to see whether there's been tampering. Of course, mobile phones have all sorts of interesting data on them. Clearly, they report their location to the carrier several times per minute. Otherwise, the carrier wouldn't know where to send the cell phone messages. There's quite a bit on mobile phone tracking there on Wikipedia. As we're all aware, computer browsers, including Chrome and Internet Explorer, and to a smaller extent Firefox, report multiple data back to Google and Microsoft frequently. And in addition to that, there are third parties that have rented the ability or tacitly acquired the ability with computers to report all sorts of multiple data, including things like keystrokes. And this is something that's very interesting to note, during World War II, German telegraph operators were able to be identified by Allied telegraph intercept operators by the microscopic changes that were audible to an experienced listener between sequences of Morse code digits. So that, for example, that was an audible signature of an individual operator. Now, the Allies didn't know the names of these operators, but they knew, for example, that there was one guy that was in maybe a very important mission, like sending information to the front lines of the Battle of the Bulge. Well, if they later pulled him back, and you could identify it by listening to him reporting from a position in Germany as the Germans retreated, you might conclude that that very important telegraph operator was now in a new area, and you might have a very important initiative coming from the Germans in that area. So that type of information is available and can be analyzed, and there's a lot of examples of that with keyboard usage. We're all familiar with social media and mobile applications ranging from Facebook to Starbucks coffee apps that know where we are, so that if we're walking down the street, they can suggest that we turn right and get a Starbucks. But that can also potentially establish motives, and it can establish trajectories of people and identities of people walking through cities. And these apps record constantly, and we don't always know from downloading them which ones do that. Now, interestingly enough, there's an entire new field called behavioral analytics. The company that pioneered it, or the two, were companies that I know of from the counterterrorism community and that everyone knows about because they buy their light bulbs, Omniscient and General Electric. They both have competing systems. General Electric is probably more for stores, but Omniscient, in real time, through a video surveillance camera, can look at a guy walking up to a woman in a parking lot and embracing her and determine from the accelerations of the articulated joints and from the rotations of things like posture whether this is an attack or whether it's a kiss of a passionate lover. That's a big deal. And that's available now for analysis. Going on to the next slide. Our cars have two sets of recordings. I've mentioned one of them here. Actually, I possibly have one on the next slide. Cars have what are called event data recorders, EDRs. The intention of an event data recorder was to continually record information so that they could apply the correct amount of energy to a seatbelt, to an airbag discharge unit, and also to a locking seatbelt, so that just the correct amount of energy was applied. Airbags deploy so violently that they can actually injure people of smaller stature and children. But they record position, throttle sensing, seat position, a lot of different variables. They vary from manufacturer to manufacturer, but they have certain minimum amounts of information that they record. They're installed in your car, and they need not be used in cases of accident. For example, if there was an allegation that a very tall person had just robbed a convenience store and got away in a car, and that car was later determined to have had a seat position so far forward that a person of that height could not possibly have driven it, that's very useful evidence, but it's only useful evidence if you know that there is an event data recorder in the car. Now, sensor data, I've been mentioning the sensors and the types of recordings, but it's important to know that sensor data can be stored either locally or in a distributed fashion, and it can be both. If you watch enough television, you've probably seen this delightful commercial where there's an older guy who has a cottage on a lake, and the son comes up with his wife or his girlfriend or something, and the dad says, so, did you lock up when you left? And the son says, oh, yeah, we locked up. And so the father then looks at his iPhone where he has enabled sensors in the house, and he finds out that the front door isn't locked, and he locks it. Lights aren't turned off, he turns them off. The television isn't turned off, and he turns it off. And he looks up at the kid and says, yeah, sure you did. Hey, have a good time while you're here. Well, if you think about it, what that means is that the local sensors on those items know their state. Apple certainly knows their state, or the provider of that app. They may be the same. I'm not familiar with the app because I don't use it. But they may be different, and they certainly don't have to be the same. As well as the cell phone on which that control was exercised, all actually know things like the positions of microwave oven doors, refrigerator doors, door locks, lights, HVAC systems, heating, ventilating, and air conditioning systems, and those are all available. If the person says, well, I couldn't have done that, Your Honor, because I was wearing a sweater, I was so cold, I couldn't have pulled that out of my waistband that quickly. Well, if it was shown to be 85 degrees, that doesn't sound very likely. But if it was 40 degrees inside the house, that's very likely. Now, servers, ranging from iTunes to Amazon to Cox and Comcast and Facebook, preserve multiple types of data that are sent and received on computers and mobile devices for everything from broadcast television to on-demand, as well as simple internet packaging and sensing and traffic. And that is toll bridges and toll roads, lots of traffic lights, police departments' stolen car units, and even private companies routinely scan and record license plate data at entry points, choke points, and also in cities at large. And they do this by the tens of thousands. If any of you have driven over the Golden Gate Bridge lately, what you'll understand is that they don't have toll booths there anymore. You drive through, they get a picture of the license plate, they're very, very good at it. It's less well known that private groups are basically working for insurance companies, and they're doing very honorable work. They're looking for stolen cars. And they drive down the street, and they can record up to 10,000 license plates per day. Upon subpoena, these people are able to provide you with license plate numbers that you ask for. And that literally is information that's there for the taking, for both civil and criminal reasons on both sides of the case. Now, an emerging standard is that modern vehicles, either now or in the very near future, depending upon which car you're talking about, will be transmitting useful information to other vehicles right next to them in what are becoming known as V2V formats, vehicle to vehicle. As you may be aware, there is a great push to go to driverless cars on the roads. There are people who predict that by 2020, driverless cars that do not require a driver in the driver's seat will be allowed on roads. Now, the consequences of that for personal transportation are profound. I don't want to get into those today because they're profound in other ways. But in particular, cars will be transmitting information about acceleration, sideways movement, fuel status, weight, dynamics, to the car next to them in one of a number of short-range formats ranging from Bluetooth to a couple of other electronic formats, which means that the information will be stored and it will be shared. And if it becomes important, that will be available. Obviously, we're all familiar with workplace computer systems. They're typically required to journal emails and in some cases web references for several years. Now, I'm in Santa Barbara, California. Some of you may or may not have read in the legal journals that there was a pretty high-profile confrontation between the owner of our local newspaper and several of the organized labor bargaining units at the newspaper. And in one case, a publicly available computer that was used by a key individual was found to have child pornography on it. Now, the fact that it was publicly available and that it was in a foyer did not stop the owner of the newspaper, probably through naivete, from attempting to bring action against the chief editor of the newspaper. The FBI was shown the evidence and decided that they had no interest in it whatsoever because there was no chain of custody and there was no evidence. There was no chain of evidence. But it got so large that it involved the National Labor Relations Board here locally, and a town of 120,000 people. You don't typically see the NLRB in places like this. But it's very important to note that that information is there, it is preserved, and it's searchable, and it's discoverable. Now, many of you potentially work in e-discovery, and traditional e-discovery, of course, is more structured than what I'm talking about because e-discovery typically was working on business-type computers or certainly computers that were identifiable as to custody and location and identity. So I tend to view the Internet of Evidence as simply an extension of e-discovery to everyday life, and there's an overlap, and of course there are going to be areas that are properly described as both. The point that I had in talking about the Internet of Evidence was simply to underscore how much more data is available and how much more ubiquitous it is. The net effect is that sensor data is literally exploding. IBM has begun to pay very serious attention to it. There's a notion in the data community known as big data. Roughly speaking, everyone has their own definition of big data, but roughly big data is masses of data that are so large that very often individual record searches are not what you're looking for. It's more for things like trends. So examples of big data would be all of the people who drive onto the Golden Gate Bridge in a day. You kind of don't care about any one individual one unless you're looking for that one person. But big data consumers are usually interested in things like the percentage of trucks at 9 o'clock in the morning or the percentage of commuters at 7 o'clock because they want to make use of that information. But IBM, a major player, decided that ubiquitous sensor data was so large that they are actually developing big data solutions that take that into account. And a phenomenon has to be fairly significant before IBM devotes a product area to it. They're doing that now. Now, the phenomenon is clearly going to get larger. We have a new Internet protocol that's coming out called IPv6, which I won't get into right now, but will allow for a lot more connected devices. Self-congratulatory media that likes to talk about how cool all this stuff is talking about 37 billion devices, and I apologize for the misspelling, I missed it. That will be connected by 2020. I'm not a great person who tries to put numbers on future predictions. I'm usually wrong when I do it. I think most people are. So I'm mentioning this because of the fact that you'll hear this number kicked around. But the bottom line is there's going to be a lot of devices, many more than there are humans on the planet. Thought leaders have referred to this since 1994 as the Internet of Things, or the IoT. And everybody likes to create their own terms. I've certainly created mine. You can look at the Internet of Things up on the web. Others have called a larger subset the Internet of Everything. I'm just calling mine the Internet of Evidence because I work with attorneys who are in the trenches every day, and this is the kind of information that you need every day. And in fact, the legal system will have no choice but to incorporate this flood of sensor data into its practice. And that's the reason that I've called it the Internet of Evidence. And by the way, you'll probably find that there is no one individual who knows it all, because it's simply too large. It's probably collections of individuals who have area specialties. Now, I really think, and I truly believe, that I can make a case that the Internet of Evidence is as groundbreaking today as the introduction of fingerprinting at the beginning of the 20th century, or DNA analysis at the end of the 20th century and the beginning of the 21st century have been, respectively, in terms of literally moving the cause of jurisprudence and rule by law forward. Specifically, sensor data and the Internet of Evidence that records it support determination of timelines, identities of actors, truth or falsehood of alibis, intentions of actors, relevant external and environmental conditions, ranging from temperature and illumination to relative humidity and wind speed, and who knew what and when they knew it. And by the way, just as a little sidelight, this happened after I had made up these slides. You may be aware that the Galaxy 4 and 5 smartphones are able to record your heartbeat. And that's actually a big electronic challenge. Most devices couldn't even do that electronically 5 or 6 years ago outside of a doctor's office. And you now have that capability in your cell phone. The Internet of Evidence is groundbreaking. Now, just as with physical evidence, it's very important to remember that Internet of Evidence data is subject to requirements for discovery, seizure, chain of custody, and accurate transcription. Some things never change, and they shouldn't. Just like with other evidence, it's possible to be susceptible to tampering and forgery and counterfeiting, which includes altering minor items within it. And it's also possible for inadvertent or intentional loss or destruction. So those are all things that are extremely important. If you're a theorist, they don't really bother you much, but if you're working in the trenches every day, you live and breathe in the world where things have to be preserved and chains of custody have to be cared for, evidence has to be treated like gold. Now, as I mentioned, I had 2 case studies, and they both occurred in such a way that they overlapped in a single week. One of them, this one, was very consequential. I spoke to the attorney. They requested that I withhold identifying information, which I'm agreeing to do. But the situation, it was a California criminal case, and it was molestation of underage female victims by a 17-year-old male. Now, the alleged time was July 4th of 2011. The specifics were a family event for the 4th of July. There were parents, defendant, who was 17, lived with them, or actually I believe had just moved out of the home, but lived nearby, 2 younger brothers, and then an older married sister who had 2 daughters. The older married sister lived in a different part of the state. They were all going to get together for a 4th of July barbecue. The 2 6-year-old and 8-year-old had invited a family friend, a little girl who was 11. The defendant had graduated from high school early, had gotten a job as a paparazzi photographer. His claim to fame was that he had gotten a smiling photograph and a handshake from President Obama. And for a 17-year-old, that was quite prestigious. And he had gotten pictures of lots of rock stars and talent and Hollywood celebrities as well. Now, I call this the data collection that didn't happen. Family showed up together at the sister and her husband's home. That was the niece's mother. The niece's mother had to go out and get some barbecue sauce. And she turned to her younger brother and said, hey, now that you got this paparazzi job, the girls all know that you are. They want to be little movie stars. They want to dress up and take some paparazzi photos. And he said, sure. We know that he had a pretty sophisticated digital single-lens reflex camera, a Canon EOS 60D. At the time, it was a very good photographer's camera. She said, and while you're at it, here's a list of songs. Can you buy them for me from iTunes and put them on my laptop? And he said, sure. And she said, oh, and here are some music CDs that I've had lying around for a long time. Can you copy them onto my laptop? And he said, sure. And the industry calls this ripping, which is it's a reference to raster image print, and it's a term that's been borrowed from the printing industry. People talk about ripping CDs. So he said, sure, and he set off to do it. His sister was gone for 45 minutes, and he did it. And they came home, they had the family barbecue, and went on as planned. And several months later, in September, when the 11-year-old started 7th grade, she told a girlfriend that she had been molested at the 4th of July barbecue by the 17-year-old. Subsequent information would disclose that she had had several self-initiated sexual experiences with 11-year-old boys and was precocious. The Internet of Evidence involvement is that after this happened, obviously things went south in a pretty big hurry. The confidant told the confidant's mother. The mother called the mother of the sister. The sister called the police. The police investigators got involved, obviously, as they should. The young man's alibi consisted of testimony that he was too busy doing the digital tasks that he had been tasked with to have committed any crime in 45 minutes. It's a realistic alibi, assuming that the truth was there. The victim interviews were done by a male investigator with no specialized training in that area. Psychological evidence was brought up in court. I was not briefed on it. I'm not discussing it. It's out of my scope. However, importantly, the same investigator determined that there was no point in preserving digital evidence. His view, which he testified to in court, was that there was nothing that could possibly have had any probative value at all. So they didn't even grab it. Now, if you actually think about that, the potential evidence that was there consisted, number one, of hard drive data on the laptop. The time and date stamps of all of the files that would have been created during that time would have had relevant information. And in addition to that, even if you delete a file, as most of you are probably aware, the data in the file doesn't go away. The analogy that I have used in court many times to explain this is if you think of a traditional library, a university library with a card catalog, if you pull the card out of the card catalog, the book is still in the library. It might be a little job to find it, but it's still there, especially if you know the name of it and you can search it quickly. But really, the only thing that happens in a file is that you remove the card from the card catalog. You erase the first letter of the book's title. You replace it with the Greek letter sigma, which is the Greek letter for, in Roman alphabet, S. And then you put the card right back into the same place in the catalog. Now, if you're going through and you file, and you're a file system and you're going through, you'll ignore things with sigma. But if you're an investigator, you won't. But it won't show up as a file. It'll show up in the part of the hard drive that hasn't yet been erased, called the non-file area. And of course, there are ways to get around that by using things like a military-grade erase or a military-grade reformat. But the majority of times, that's not done. And if the person goes back to look afterwards, they don't necessarily have the tools to do that. In addition to that, there were photographs taken with a Canon camera that had a memory card. And the memory card included the file system data that I've mentioned, as well as the EXIF header data. And there was also iTunes transaction data that included time tags. Now, iTunes transactions, some of them can be batched, some cannot, some have to be done individually. There was also potential data with the Internet Service Provider recording packets. Everyone is different. Everyone has different standards, but all of that is obtainable by subpoena. There's also potential georeferencing data from any cell phones that could even indicate movement from room to room or from outside to inside. There may even have been other data, but that was the data that I became aware of during my investigation. Now, my argument was that all of that data should have been aggressively and jealously recorded. And then analysis should have included a reconstruction of the activities that were needed to achieve the digital results shown by the evidence. For example, if you have a new file created every minute for 23 minutes and in a process that could not be batched, that would require that the person be available every minute at the keyboard to perform that transaction. So to reconstruct an activity, that person would have to have been there pretty much the whole time. If it was batched, maybe not. Some applications could be batched and some were not. The court was not interested in a reconstruction of a timeline based on file data because, of course, there wasn't much at that time. It had not been grabbed at the time and it was erased. Potentially, you could even reconstruct the rooms that were visited by the relevant parties. And by the way, if an innocent, by now, a 20-year-old is put away for life for a crime he didn't commit, that's a gross miscarriage of justice. On the other hand, if a guilty child molester is released, that's also a gross miscast of justice, misuse of justice. There really isn't a fallback position here that's safe. This is very, very relevant no matter which way it comes down. Truth is very important in this. Well, those of you who fight these battles on a day-to-day basis in court are well aware resolutions are rarely clean. Victories are rarely sweet. The trial lasted about 15 days. Evidence was not gotten. Most of the evidence was erased by the time it was available to do it. The testimony that I could bring to bear, unfortunately, was only what might have happened. There were 14 counts. It was life without parole due to the alleged victims and multiple victim enhancements, the age of the victims. It caused a family split with a sister on one side and the parents and the defendant on the other side. Interestingly, the two young nieces recanted their testimony and claimed that they'd made it up. The defendant was acquitted on 6 charges. The jury hung on 8 additional ones. The DA is still in a decision loop regarding whether to refile a different defense counsel. I believe they're going with a public defender in this case. No clear resolution on either side. I'm still of the opinion, my analysis is, I don't think that the justice was well served, and I always hate to see that, as I know all of you do. What should have been done was that all Internet of Evidence data should have been impounded immediately. And perfect copies should have been created using any one of a number of NIJ-approved passive copy devices. I certainly have one at my office, and there are plenty of them out there. In fact, you frequently have to buy on demand because data formats change so rapidly. Relevant documents to which we had no physical access, such as from the Internet Service Provider, iTunes, other vendors, should have been subpoenaed while you could. Then when you get the evidence secure, and only then, you determine if the data has probative value. Maybe it doesn't, but don't make that call ahead of time. Get it now. Now, if the probative value can't be ruled out, then you go ahead and analyze it. And you want to use a qualified expert. Obviously, analysis is a commitment of resources. You don't want to commit resources unless you have a reason to believe that committing them will buy something towards the service of justice. But you should get the easy ones. You should absolutely impound the evidence. Now, if you decide to go ahead and commit the resources of using qualified experts to do the analysis, you may have experts on your staff. I was privileged to work with the Sheriff's Department of the County of Riverside on a similar case about 2.5 years ago. They had some really, really qualified experts on their staff. They did a great job. And I was brought in as a pinch hitter. Not every county has that. Not every county can spare them. But there are actually a lot of very, very good specialists all over. I certainly specialize in some areas, not in others. There are university professors, there are ex-law enforcement people, there are ex-military, there are ex-intelligence community people who are out there, all of whom are able to bring some serious expertise to bear. And vendor selection is not hard to do in the days of the Internet. So let me pause right now, and there are questions, see if there are any questions. I didn't look just yet, but if there are any questions, I'll be delighted to entertain them.
Before we begin the question and answer segment, I do ask that all attendees type in the passcode that was given at the beginning of the presentation for the CLE credit. And we do have a question. What particular training can one obtain to become proficient as an Internet investigator, and does the presenter see this as a good employment opportunity?
Well, it's a very interesting question about training. There was a time when you had to go to a classroom to become trained, and suddenly we ended up with the Internet, and right now there isn't any reason why that training can't be done online. There are a lot of people out there who offer certificates. It is not, I would tend to think that it's a good area to start in, and it's in particular a strategic area. So I guess I would say yes to both questions superficially. Picking your training is probably important. And right now, I believe that education in general is undergoing a stupendous revolution of the type that it may not have seen in a very long time, roughly since we invented the notion of a classroom in the 1600s in Europe. And I would say to get the training from an institute that's quite respectable. I can't tell you which ones they are right now. In my particular situation, I started writing software when I was 12 in 1959. I was employed as a programmer before there was the first degree offered in computer science, which was MIT 1970. I was already writing software for NASA. So I haven't really pursued a formal training career in my own software experience. But if you'd like, if you want to send me your email, I'll do the background research and I will take it upon myself to get recommendations and send it to you.
Okay, I think that is all for questions that we have right now. We will have another question and answer segment. So, Wayne, you can continue on with the presentation.
Sure. Thank you. Okay, this is our second case study, and again, this is one that I did in the same week. I referred to it as a text message from who knows where, and again, by request of the attorneys, the identifying information is withheld. It was a California criminal contempt case. If there's something good to say about a divorce, I don't know what it is. I went through one. They're never easy. My hat's off to anyone who goes through it. If you're a divorce attorney, my hat's off to you doubly. I don't know how you're able to do that, and you have nothing but my respect. The wife, who was the one who initiated the divorce, alleged that she had received text messages on her cell phone from her husband's cell number as a callback number, saying, "Oh, I love you, I don't want to get divorced, please come back," but that those were in violation of a no-contact court order. For background, the husband is a successful business owner in Southern California. The wife herself actually is a divorce attorney, obviously who had retained other counsel. There is disputed custody of the couple's 6-year-old daughter. The husband alleged that in order to gain additional leverage in restricting his access to the daughter, that the wife knew his cell phone internet provider's password, and that she or a co-conspirator had logged into that that cell phone provider's website, forged the husband's identity on a web page that allowed text messages to be sent, and sent them under false flag. Now, text messaging from this particular vendor, and there are plenty of them out there, and they're all different, but this particular one had a page available where you could just send a text message, and when it arrived on a cell phone, it appeared to have come from the cell phone number that was associated with the login. Now, the husband was incensed. He took a voluntary polygraph test. The polygrapher asked, "Did you send those messages?" He said, "No." The polygrapher registered strong no deception indicated, NDI. I used to be in the polygraph business. That means that the husband passed the test. Polygraphs are clearly subject to a lot of challenges, many of them relevant challenges, some of them not relevant. But for the record, that was what happened. Now, the question that I was brought in to answer, the Internet of Evidence issue was, if such a forgery were in fact perpetrated by means of a web login, which is actually known as a web gateway, instead of an actual cell phone, would such a forgery be detectable either from the receiving cell phone number or from the web record? In other words, could a forensic examiner look at the wife's cell phone and say, it came from a web gateway, not from the actual cell phone? Or could a forensic examiner go to the web and look at the person's account and tell from the text streams whether they had come from a genuine cell phone? And interestingly, the answer is no. And that may actually seem surprising. I found it surprising. But upon deeply researching it, it turns out that text messaging is a very, very old format, as such formats go. Remarkably, there's actually no international standard. Now, there are standards. When you send internet packets, they're actually a standard that's accepted by governments. There are standards organizations that maintain them. There's standards that maintain the voltage in your wall. But there are literally no internationally accepted standards for text messaging. There are many that are informal standards, but they're not formal. None of them retain path data, or what the industry refers to as envelope data. And it turns out you literally can't tell whether a message that arrives as a text message on your phone and looks like it came from a cell phone actually came from a cell phone, or if it came through an internet gateway. Now, if you send an email and it is sent out as a text message in what's known as an email gateway, you can tell, but that wasn't the issue here. Well, obviously the cell phone provider could have told, because they do keep records. But as you can doubtlessly imagine, they have billions of records that they need to keep, and they can't possibly keep them forever. Retention lengths vary. There is no legal standard. However, this particular cell phone operator deleted them and did a hard delete, an unrecoverable delete, after 10 days. Presumably, the NSA had a gateway in. The NSA may have retained it. They're not going to give you information because the fact of whether they do it or not is technically still classified, even though there have been news reports to the fact that they did. And if you notice, my words were couched in probabilistic terms. I think it's likely that they do, but certainly none of us has definitive evidence. But they're not going to share, and by 10 days it's too late. So this is very, very important and underscores what I've seen before. This is from the trenches. Go out, get that data. Get it before it's too late. So the resolution was that the text message charge of contempt of court was dropped. It may have been refiled. I don't track the case. I'm no longer involved in it. I had just heard through the grapevine that the court was considering refiling it. I don't have information as to why. I do know that it was not for digital reasons. But, again, what should have been done? Impound all the Internet of Evidence data immediately, because it's the right thing to do, because you can, and because you should. For information that's available to you physically, create perfect copies using NIJ-approved passive copy apparatus. For information that's not available to you, subpoena the relevant records from the relevant providers before the destruction date. And since you don't know what that is, earlier is always better than later, unless it's a bill for services that you pay for or your own funeral date. Earlier is better than later, except in those cases. Then, after you have it, then go ahead and commit the resources to analyze it, see if it's relevant, and if it is relevant, analyze it for what it means. But if I have any summary, my summary is that the Internet of Evidence is potentially as much of a game changer for civil and criminal jurisprudence as fingerprinting and DNA analysis were in their respective days. It exists literally everywhere, and it's very important in many contemporary legal matters. Not only that, it's going to increase. It increased while we were in this webinar. It will increase before you go home tonight, and it will continue to do so. In the case of the molestation allegations, availability of that data may have profound consequences, where you either have a guilty party being turned loose or an innocent party being incarcerated for the rest of their life. And, as of course, with everything else, it's not magic. It may not exist in all cases. If you get it, it may not prove a thing. So I still recommend, and this is somehow new and somehow old, e-discovery is a wonderful field, and the e-discovery has helped us flesh out a lot of rules. In fact, I see that there's a question that just came up. It says, for lawyers, what do the rules mean about clients' confidentialities, information, and disclosure? You know what? That's great. I actually attended a seminar last night in preparation for this, and also because I couldn't not. It was put on by a ubiquitous commentator whose name is Doc Searles. He is a visiting professor at MIT. He's been a consultant to the FBI. He has had a front page article in the Wall Street Journal. He's written for the New Yorker. We were discussing privacy last night. Privacy is literally all over the map. I wish I could give you, and I'm not a privacy specialist. I do work with privacy, but my specialty is the technology portion of it, and that's because the privacy issues go past just the technology and get into the legal portion, and I'm not trained as an attorney. I wouldn't want to imply that I was. Now, there is a notion that there are two related items that feed into one another. One of them is privacy, and the other one is security. Security refers to the way we protect information, and privacy refers to our expectations that are regarding it. So, for example, it may be that simply removing identifying information is okay, but it may not be. There may be other items as well. And, it's certainly something that we could discuss if there are more directed questions. But I wish I could tell you, for example, I don't know whether HIPAA standards for privacy for medical would throw an additional barrier into pulling up recorded biomedical data from your cell phone. That wouldn't even have arisen 5 years ago, but it does today. And I don't know the answer to that. And my guess is it's probably never been adjudicated. I'll bet the people who wrote that law didn't think about it. But anyway, but thank you for that question. The rules that I would follow, and I haven't coded them yet, I may, on my website, identify where the evidence can possibly be, and remember the time is of the essence, and then preserve it. Impound it if you can. If you can't, you can at least write protect all of the evidence immediately. If you can't get to it physically, then you have to subpoena it, and you have to subpoena from everything that moves. Internet service providers, third-party vendors, the person who wrote the app, and you have to do it while it's still available. And preserve all of the writable media, such as hard drives, from being overwritten if you possibly can. Now, you have to gather it. That's not the same as preserving it, because in the case of the subpoena, you actually have to create the copies and put them all together. Then, you may need to do some processing. If someone said, oh my gosh, they're coming after me for child pornography, I'd better erase all of the instances of Lolita, the word, on my hard drive, so that it can't be found by aftermarket analysis software, you may have to go in and do a forensic data recovery, or you might have to take other measures. Then you review and analyze it to determine what's relevant, and then produce it for court. And I've done these in order of priority and also in order of escalating value add for committing the resources, because if you work in the trenches, as everyone I work with does, the cost of expertise is very important, and it has to be able to be justified by the likelihood of results. Now, once you've got it secured, as I mentioned there, then determine if it has probative value. Now, if you have an expert on your staff, wonderful, do it. But if not, go on the internet, because there are specialists all over. And I really can't stress this enough. The field is so large that no one individual can be treated as an expert on all areas. I was privileged to attend a lecture in forensic data recovery in San Diego about a year ago by a gentleman who had about 12 years counterterrorism, FBI prosecutions, drug terrorism from Mexico. He didn't know one end of Facebook from the other end of Twitter. That's fine. But if you consider that Facebook and Twitter are evidence and the rules are important, then you need to know that. And you're probably not going to find all that in one person. So you are going to have to go to different experts. I would even submit that forensic experts in areas of social media are probably relatively few and far between, because it's so new. Individual specialists may be needed to research highly case-specific questions, and for anything that resembles a large or complex case, you may need one expert who will function as a lead investigator, or project manager, or project coordinator. Now, I'm going to leave with some final words that even though the Internet of Evidence has only recently arrived, it has profound and potentially sobering consequences. First, back. There were 0 cell phone photographs or movies from inside the Twin Towers. For those of us of a certain age, it seems like only yesterday. It sounds like listening to my parents talking about Pearl Harbor as though it were yesterday. Remarkably, those devices are now the most common platforms for watching and consuming not only NFL games, but also rock concerts after television. In some countries, they're larger. This is very sobering and very, very sad when this is something that I experienced when I was working counterterrorism. A new fleet of helicopters arrived with an aviation unit at a base in Iraq. It was out in a forward operating area. Some soldiers, young guys, 18, 19 years old, kind of got seduced and were sending a bunch of pictures of them flexing their muscles to some hot-looking girls in Sweden. Unfortunately, those were internet photographs that were posted by some very smart Al-Qaeda operatives who live in Sweden. They were able to look at the exit headers. They determined the exact coordinates of the helicopters inside the compound. They conducted a mortar attack, destroyed 4 of the H-64s. I believe they may actually killed one of the guys. Very, very scary. See, there's another question that just came up. I want to make sure that I answer it while I'm on the question here. Let me see. Okay. Now, this is a question: can data be recovered if the hard drive has been overwritten? And the answer is maybe. If the hard drive has been completely overwritten and it's a modern hard drive, it cannot. And in earlier times, it could. And here's the reason. The hard drive surface, we've probably all seen pictures of them. They look like little round, very, very shiny mirrors and with tiny little areas that are magnetized. And if you were to overwrite every single part, then you couldn't. Earlier hard drives had little magnetic write heads that did not always return to exactly the same place. Even though they deposited a new magnetic recording that was strong enough to be read, the prior one might still have been available on a portion of it. In the same way that, for example, if you were to lay a postcard on top of an envelope, some of the envelope might be visible around the edges of the postcard. But in hard drives that were manufactured after, and it's getting to be a long time now. I think it's 1997 was when they finally had that breakthrough. We could look it up. The dimensional tolerance with which the write heads came by was so good that edge effect reading became impossible. What a military-grade erase does is actually write a random pattern of ones and zeros to all points of the hard drive, and that would do it. Now, a lot of times when you say overwritten, however, what you don't necessarily mean is a military-grade erase or a full overwrite. You might only talk about overwriting part of it. And in that case, maybe the area you're looking for has not been overwritten, and maybe it has. But if either the area you're looking for has been physically overwritten, or if the references that tell you how to interpret it have been physically overwritten, then retrieving the data is pretty difficult. Now, the next question was, who owns the duty of privacy and security? The carriers, the manufacturers, the users, the consumers. Fascinating question, and the answer is, we don't know. Usually, I try not to make definitive statements that look like I know what I'm talking about in the law, because I'm not an expert in law. I have been to enough attorneys and been through this with enough attorneys so that I can tell you that unless you can find a specific statute that's going to be very, very broad, or even rarer if you can find an appellate decision that's going to be very broad, and there haven't been many because they're very new, you're going to find that these are not well defined. There is a notion that we don't have any privacy, and if you think we do, get over it. That was actually John McNeely, who, if he hadn't made it as the CEO of Solaris Computers, he would have made an excellent stand-up comedian. But it's very, very difficult to do that, and you get into trying to establish the requirement or the responsibility, and you enter into a legal thicket. I mean, it's going to get resolved, and it's the right question to ask, but it doesn't have an answer right now, at least not to my knowledge, and that was as of the last time I checked, which wasn't long ago. Okay, and let me go on to the next slide. And this, again, very, very serious. During Israel's 2006 war in southern Lebanon with Iranian-backed Hezbollah, Iranian SIGINT professionals and the Iranian intelligence services are as good as any on the planet. I will stand them up against the Chinese. I will stand them up against the Russians, the Americans, and the Brits, and the Israelis. They're that good. They track signals coming from personal cell phones of Israeli soldiers to identify the assembly points. They're all back home calling their boyfriends and their girlfriends because obviously the IDF has frontline troops that are both men and women. And if you get a whole bunch of telephone calls coming back, even if you can't read them, that's message traffic analysis. That looks like a really good target to lob a mortar shell. It also looks like a place you might be thrusting into Lebanon. There's multiple reference provided for that. If you're a war planner or if you're in the legal profession, you need to know that stuff because that might mean life or death tomorrow or today. I'd love to answer any of your questions. Obviously, I do this for a living, but I do this because I love it. I wanted to be a physicist when I was 5 years old. Here I am, 67. I had a career as a physicist, and the spark never goes away. Feel free to contact me. I basically always pick up the phone. The internetofevidence.com just came up today. If it's a little rough, I apologize. It will get better. My CV is there. and I would be delighted to help you or answer you because I love the technology and I really believe in justice and the rule of law. And I thank you very much.
Thank you, Wayne. Before we do the second question and answer segment, I'd ask that all the attendees type the CLE passcode once again. And we do have some questions. Could you provide examples of estimates of costs associated with retrieval of data?
You know, that's actually interesting. In many cases, it's much, much cheaper than you might think because it's a very efficient process. In my own case, I charge $295 an hour, but I charge half time if I'm just traveling or something, and I'm not doing anything that's research. And some of these are able to be completed in 2 or 3 hours. Now, investigators are typically able to grab the physical media, so you can have paraprofessionals or specialists in information and evidence recovery do that. But I've worked in plenty of these cases that were under $2,000, some that were under $1,000. Obviously, they can get more expensive. I actually did some work for the Internal Revenue Service. I was their lead investigator on software development issues in 1999 and 2000 in a little case they called Microsoft versus Commissioner. It was $1.7 billion with a B. It was the largest tax case ever brought in history. And it hinged on whether certain types of files were available at certain dates and whether they contained executable information. And I did a lot of that. And of course, that was a lot more money, but it was a very large case. But a lot of this stuff is actually remarkably inexpensive and can yield some remarkably valuable data.
Okay, and we have another question about Flight 370. The Malaysian airline. All passengers with their cell phones and other electronic devices that seem smarter than a fridge were missing. How come no data was recorded on a server anywhere?
Well, that's very interesting. In an earlier life, I was a airline pilot and I owned a small airline and a flying school. You should never do that. There is an old joke in the business that says the way to make a small fortune in the aviation business is to come in with a large fortune. But for my own purposes, I did try to do cell phone communication with the ground. And I can tell you from private experience, and I was probably breaking the law when I did that, and if so, I apologize. You aren't going to get cell phone data. You're not going to get cell phone connectivity over about 8,000 feet. Forget about it. Not going to happen. In terms of getting it through the little windows in an airliner, that's going to compromise it even worse. If you go 20 or 25 miles offshore, you've had it. Not going to happen. And one of the things that came up during 9/11 was actually cell phone data. What wasn't mentioned was that was all cell phone data at very low altitudes. Now, I'm assuming that because everyone listening to this are attorneys and you're all law-abiding citizens and you don't routinely try to break the rules like I did, that you haven't turned on your cell phones during flight. But unless there is this little cell repeater in the airplane, and they may have them now, because they finally figured out, no, Virginia, you're not going to drive the airplane off course during an ILS approach or a coupled GPS approach by using your cell phone. You're not going to get connectivity. So I'm not steeped in the datas in the Flight 370. I wish I were. I've read some items, but probably no more than any of you have read. I'm going to interpret them based on my background, as you will based on your background. But it is not surprising to me at all that there were no cell phone records. For legitimate reasons.
Okay. In reference to the case with the text messages, if that text info had still been available, what would be the cost to retrieve and analyze it?
Well, I don't believe that there are any charges that are allowed to be provided for subpoenas of evidence from the cell phone carrier. So almost certainly a subpoena and the evidence that comes for it would have been free aside from the service charges. And I did not detect that the companies were uncooperative. You have to ferret through their legal department. Clearly, that's not what they do all the time. And, of course, they're just as worried about any other companies getting sued. But you may have 5 or 6 phone calls to get to the person who can actually tell you where to send it. But to actually obtain the information is trivially low cost for a legal case. To analyze the data probably wouldn't have been more than an hour or so, really. I mean, it depends on the format in which it was sent. I was a telephony systems engineer for a few years, and I had a gang of guys who were writing telephone software in Novato, California, under contract. Some of the formats have changed since then, certainly, so this stuff changes every day. But typically, these are not real expensive. I mean, there's not hundreds of hours. These are units of hours or 10 hours, something. Hard to say in a particular case, but they're not typically expensive.
Okay, and then we have another question. Who owns the duty of privacy and security? The carriers, the manufacturers, or the users/consumers?
Actually, I had addressed that before, but I think the answer is it's all over the map.
Okay.
And probably a lot. And, take that as a challenge. You, whoever you are, may be the one who establishes that appellate decision. Your name may go down as prosecuting a case that actually clarifies some of this law. And if so, my hat's off to you. Thank you for that.
Okay. Data that is recorded from smart devices, is there a main location to subpoena such data or just available at an on-site recorder?
It really varies a lot. And by the way, some of these cases, for example, we have Facebook. You can connect Facebook to a lot of items. You can connect Facebook to your camera. Legally, physically and scientifically, that's recording remote data on Facebook. There were predecessors to Facebook. Some of them are no longer around. Companies are not very interested in telling you when they're ready to go bankrupt. Sometimes they go bankrupt quietly and the data is gone in 24 hours. There's absolutely no record, there's no requirement for doing that. There are, and by the way, I don't know if this isn't precisely censored data, but no one should be in this business without being aware of a utility called the Wayback Machine. If you ever watched Rocky and Bullwinkle, you will remember a reference to going back in time with a little cartoon device called the Wayback Machine. The history department at University of California, Los Angeles, many years ago, got together with the computer science department there, and they created a website called archive.org. That's archive.org. But everyone knows it as the Wayback Machine, and if you Google that, you will find it instantly. The Wayback Machine attempts to record exactly what is on the web every single day. So, for example, if you wanted to know what the General Motors website for the Ford Fusion was going back a year and a half in time, there's a very good chance that it will be there. And, of course, they've changed it. Now, there are asterisks all over that because not all web content is static. Some of it is ginned up for you with your specific case in mind at the moment that you made the request. So, of course, that isn't there. There are some others that have tags that request that they not be archived. Those are obviously bank and secure information and copyright information. They respect that. But for an enormous number of cases, it is there. That has factored into at least 7 expert witness cases that I have done over the years. I am always marvel at when people don't know it, but how should they unless someone told them? So I'm passing it on. Hot tip for the day, archive.com. May save your life. Or your case. Okay,
we have one more question. Have you ever subpoenaed info from Facebook, and if yes, what was the result?
Simple answer, I have not. and I don't know what the result would be. I'm not experienced. And by the way, let me say, I am not one of those people of a certain age who doesn't believe in social media. I am one of those people who spent 5.5 years in counterterrorism, during which the use of Facebook was discouraged for reasons which must be obvious. And so I don't really have much of a presence on Facebook. Now that I am no longer doing that, and I'm assuming that no grudges are held, I might begin to establish a Facebook presence. I'm aware of it from my wife, who is a modest Facebook user. Some of her friends are egregious Facebook users, and my daughter-in-law uses it and things like that. So, of course, I get to see it. But I haven't subpoenaed yet. I'm looking forward to that coming up. I wish I could tell you, but I will be updating my website that I just created all the time to throw up that, and I hope you check back, because I'll put that up. I'll make a point of researching that. I think that's very useful to know.
Okay, those are all the questions we have. I just wanted to remind everyone that this webinar is eligible for CLE credits in California, Illinois, Minnesota, Missouri, New Jersey, Pennsylvania, and Texas. To ensure that you received your CLE credit, please complete the survey at the end of the presentation.
And I might like to add, if any of you have any questions, I would love to hear from you.
Okay. And in addition to being your best source for testifying and consulting experts, TASA also offers e-discovery and document management solutions, free interactive webinars, and research reports on expert witnesses such as the Challenge History Report 2.0, the Professional Sanction Search, and the Expert Profile 360. I want to take this opportunity to thank everyone for attending, and most especially Wayne Norris for his time and effort in creating this presentation. If you would like to speak with Mr. Norris, or if you would like to speak with a TASA representative regarding an expert witness for a case that you are working on, please contact TASA at 1-800-523-2319. This is a reminder that we will be sending out a link to you tomorrow with the archive recording. The archive recording will also be posted in the Knowledge Center on TASA's website. If you have any follow-up questions or comments, please email Carol Kowaleski. Thank you, everyone, for attending. Have a great day.
Thank you, everyone.